Which rule of taxation holds that income should be taxed in the country where it originates? The source rule. Which rule of taxation stipulates that the power to tax should rest with the country where the taxpayer resides? The residence rule. What is the primary reason for the existence of double taxation avoidance agreements DTAAs? To prevent the prohibitive costs of international business caused by simultaneous application of source and residence rules. In the context of international taxation, what does double taxation mean? Taxing the same income twice in the hands of the same assessee. How does the exemption method of bilateral relief function? A particular income is taxed in only one of the two involved countries. How does the tax credit method of bilateral relief function? Income is taxable in both countries, but the residence country allows credit for the tax paid in the source country. Which method of double taxation relief does India follow in the majority of its DTAAs? The tax credit method. What is unilateral relief in the context of double taxation? Relief provided by a country to its resident for foreign taxes paid even when no DTAA exists between the countries. Which section of the Income Tax Act, 1961, provides for unilateral relief from double taxation? Section 91. Which section of the Income Tax Act, 1961, empowers the central government to enter into DTAAs with foreign countries? Section 90. Which section of the Income Tax Act, 1961, deals with the adoption of DTAAs entered into by specified associations? Section EA. What is the general objective of agreements entered into under Section 90 and EA? Granting relief or avoidance of double taxation and promoting mutual economic relations, trade, and investment. Under Section, how do the provisions of the Income Tax Act, 1961, apply to an assessee covered by a DTAA? The Act applies only to the extent that its provisions are more beneficial to the assessee than the treaty. Which specific chapter of the Income Tax Act, 1961, applies to an assessee even if its provisions are not beneficial? Chapter X, a general anti-avoidance rule. Is charging a foreign company a higher tax rate than a domestic company considered less favorable under Section 90? No, it is not regarded as a less favorable charge or levy. If a term is undefined in both the Act and the DTAA, where should its meaning be sourced? From the notification issued by the central government in this behalf. What must a non-resident furnish to claim relief under a DTAA according to Section? A tax residence certificate (TRC) obtained from the government of their country or territory. According to Circular No. 333, which takes precedence, a specific provision of a DTAA or the general provisions of the Income Tax Act. The specific provision of the DTAA. Who governs the computation mechanism for tax when it is not provided under a DTAA? The domestic tax law of each respective country. What is the status of treaty shopping arrangements under Section They are specifically excluded from DTA benefits to prevent non-taxation or reduced taxation through tax evasion. Which model tax conventions are commonly used as bases for tax treaties? The OECD Model Tax Convention and the UN Model Tax Convention. To qualify for unilateral relief under Section 91, what must be the residential status of the assessee in India? The assessee must be a resident in India during the relevant previous year. Does unilateral relief under Section 91 apply to income deemed to accrue or arise in India? No, that income must accrue or arise outside India and not be deemed to accrue or arise in India. What is the requirement regarding the payment of foreign tax to claim relief under Section 91? The assessee must have actually paid tax on the foreign income in that country. How is the Indian rate of tax defined for the purpose of Section 91 relief? The Indian income tax after normal relief but before double taxation relief divided by the whole amount of income assessed in India. How is the rate of tax of the said country calculated for Section 91 relief? Foreign income tax paid after country relief but before DTR divided by the whole amount of income assessed in that country. What is the formula for calculating the amount of deduction under Section 91? The doubly taxed income multiplied by the lower of the Indian rate of tax or the foreign country's rate of tax. According to Notification No. What nationality information must an individual assessee provide for treaty benefits? Their nationality. If a tax residence certificate TRC already contains a piece of required information, must the assessee provide it separately? No, the assessee is not required to provide information already contained in the TRC. Which authority is empowered to notify a specified association under Section IA? The central government. The principle that does override domestic law in case of conflict if more beneficial was upheld in which Supreme Court case? CITVPVAL Kolindigin Chetire 2004. For Section 91 relief, should the Indian rate of tax be calculated before or after double taxation relief? Before deduction of any double taxation relief. What happens if the Indian rate of tax and the foreign rate of tax are equal under Section 91? The deduction is calculated at the Indian rate of tax. Which rule holds that the power to tax should rest with the country in which the taxpayer resides? The residence rule of taxation. Under Section 90, agreements may be entered into for the exchange of information to prevent evasion or avoidance of income tax. What is the purpose of Section ERD regarding international tax cooperation? The recovery of income tax under the Act and the corresponding law of the foreign country. Does Section 91 relief apply if India has a DTAA with the country where the income arose? No, Section 91 only applies if there is no agreement for double taxation relief with that country. According to Notification No. What must an assessee provide if they do not have a tax identification number in their country of residence? A unique number on the basis of which the person is identified by the government of that country. Under Section 91, where must the income have accrued or arisen for relief to be granted? Outside India. What does contracting state refer to in the context of a DTAA? one of the two countries that are parties to the tax treaty. For Section 91, the rate of tax of the said country includes super tax, truffles, true. Can a third-party resident not of a contracting state typically claim DTAA benefits directly? No, DTAAs are intended for residents of the contracting states, and section prevents unintended benefits through TRC requirements. What determines the effective date of a meaning assigned to a term by a central government notification for DTAA? The date on which the agreement came into force. The Indian rate of tax calculation, or text Indian rate of text tax or text whole amount of income assessed in India. If a term is defined in the Income Tax Act, 1961, but not in the DTAA, which definition is used? The definition provided in the Income Tax Act, 1961. Which administrative body issued Circular No. 333 regarding the precedence of DTAAs? The CBDT Central Board of Direct Taxes. What document serves as proof of tax residency without further conditions for prescribed particulars? A certificate issued by the government of the foreign country or specified territory TRC. Name one of the countries India has a DTAA with as mentioned in the text. Switzerland or Sri Lanka, Sweden, Denmark, Japan, Germany, Greece. What is the role of Rule 128 in Indian taxation? It provides the foreign tax credit rules for granting credit to resident Indians for taxes paid in another country. In bilateral relief, if an income is taxed in both countries but the resident's country allows credit, it is the method. Tax credit. Section IA empowers the central government to implement agreements made by specified associations in India with associations in specified territories outside India. Does the more beneficial rule of section allow an assessee to ignore GAAR? No, Chapter X of GAAR applies even if its provisions are not beneficial to the assessee. What information regarding residential status must be provided under Notification No. The period for which the residential status mentioned in the TRC is applicable. Is a firm required to provide its country of registration to claim treaty benefits? Yes, as per Notification No. Non-individual assessees must provide their country of incorporation or registration. Under Section 91, the deduction is granted from the payable by the assessee. Indian income tax. If a taxpayer is a non-resident in India, can they claim unilateral relief under Section 91? No. One of the conditions for Section 91 is that the assessee must be a resident in India. Which section specifically addresses double taxation relief for agreements with specified territories? Section 90. Can the central government notify the meaning of terms used in a DTAA? Yes, under Section and IA, provided the context does not require otherwise. What is the effect of globalization on domestic tax policies? It has led to a visible impact of one country's domestic tax policies on the economy of another, requiring continuous assessment and reform. Separate in a DTAA deal with various categories of income like interest, dividends, and royalties. Articles. To compute Section 91 relief, one must compare the Indian rate of tax with the rate of tax of the foreign country. Section deduction, or tax deduction, a tax doubly taxed income times taxed lower of the Indian rate of tax or the foreign rate of tax. What determines if a charge of tax on a foreign company is less favorable? It is not less favorable simply because the rate is higher than that for a domestic company. Are the computation rules for tax usually found in TAAs? No, they are generally governed by the domestic tax law of each country. In the exemption method, income is taxed in of the two countries only one. Which section covers bilateral relief with countries outside India? Section 90. Can the Indian government enter into agreements for the investigation of tax evasion cases? Yes, under Section IRC. What is the status of Section 91 if the income is deemed to accrue in India? Relief is not available. The income must accrue or arise outside India and not be deemed to accrue in India. For the foreign rate of tax under Section 91 is the numerator tax paid or tax payable, income tax, and super tax actually paid. What must the assessee maintain to substantiate information provided for treaty benefits? Necessary documents to substantiate the status, nationality, tax ID, and address information provided. Double taxation relief provisions are contained in Sections 90 IA and of the IT Act 1961. 91. What is the primary criteria for specified association under Section IA? Any institution, association, or body notified by the central government functioning under Indian or foreign law. TAAs laid down rules for taxation by source and residence countries. Allocation. Is Section 91 relief available to a foreign company resident in India? Yes, as long as the assessee is a resident in India during the relevant previous year. The Indian rate of tax excludes double taxation relief in its calculation. True, false? True.